guys. Hope everybody else is having a good day. I'm having a good day. Despite my fall yesterday, I did not have a good evening. Um, but my wonderful husband brought me dinner in bed. He put icy hot on my back. In case you weren't here yesterday, I was looking for something that I thought I had dropped on the floor. I had not. It was on my desk under stuff, but I thought I dropped it on the floor. And I was on the edge of my chair, on my rolling chair, and the chair rolled out from underneath me, and I went splat on my butt. And I already have back issues. If you're a regular viewer, you know I'm in the middle of getting things done to my back to correct the problems that I have. Um, but I'm feeling better today. It's a little sore, but it's not like it was last night by any means. And I'm having a good hair day, and I'm getting new internet today that should fix the little glitches that I have with StreamYard. So today's a good day so far. We have a Karen Reed hearing this morning, and if that doesn't take all day, we will jump back to the dog park murder trial. And the internet people are supposed to be here between 3 and 5. So whenever they get here, we are going to have to stop because I won't have internet because they will, this one will stop and, well, I don't know. Yeah, I guess this one will get disconnected and that one will get connected. Yeah, so we'll have to stop because I haven't told this company that I'm ditching them because I'm gonna wait. Like I'm gonna keep this connected if I can, as long as possible. Like 2 3 months maybe, like to make sure that I like the new before I totally get rid of the old, just as a safeguard. Um, so yeah, we might. Yeah, I got a good one. I got a good one. I really, really did. And I was 38 when we got married, and there are so many guys I dated that I just wanted them to be the one, and I'm so glad they weren't. I was even engaged once before him, and I'm just so glad I didn't make any of those mistakes. So glad. So, so glad. I don't think they have started yet. It says waiting for Law and Crime Network, but they have not started yet. So I don't know what we're gonna do. I should have waited till they started. But I made it for 9 because I have been starting the dog park trial at 9. Well, we were starting the Colin Griffith trial at 9 because they were starting at 8:30. So that way we started a little bit late and we could get caught up. Yeah, you live where it snows. We got snow in the panhandle. I was so disappointed. I was so disappointed because I wanted snow. And here I am, like 3 4 hours away in Florida where they're getting snow. And I was like, it's not fair. Like for weeks, I was saying, it's not fair. If it's going to be this cold, we should get snow. It's not fair. Oh, wow. Yeah, our schools were closed. And this is where I live. Even though it wasn't snowing, our schools were closed. Trying to think what else was closed. The airport in Jacksonville was closed. I don't know. I don't think it snowed in Jacksonville, but they still closed the airport. And people In chats, people up north were like, "Why'd they close the airport?" I was like, "Because people in Florida don't know how to deal with snow. That's why." We have no idea how to work. We don't know how things work when it snows. We don't know what to do, so we just hunker down. Like we have no idea how to act in the snow. None at all. Absolutely no idea. Um, I remember one year, it was in the 80s. Hey, Draco. It was in the 80s. It snowed. We lived we lived in Bronson, which is about 20 minutes from where I live now, south of where I live now. And it snowed and it just melted as soon as it hit the ground. And the only place it accumulated was on the picnic table because the picnic table was cold enough that the snow didn't melt as soon as it hit. And mom made a snowball and then put it in a Ziploc bag and stuck it in the freezer. And I was like, Mom, why are you putting a snowball in the freezer? And she said, to keep it. Why do you want to keep it? Just because to prove we had snow. I'm like, who are you going to prove it to? What? What? My mom could be ridiculous at times. I'm like, why? And I don't know how long she kept that snowball. We finally threw it away. I'm like, why are you keeping a snowball? You're ridiculous. Um, so that was in the 80s. Um, and my dad was a highway patrolman at the time. So he had to work extra. Like all the patrolmen had to work extra shifts because people don't know how to drive in the ice and the snow in Florida. And the snow was not accumulating on the streets, but it was icy. So there were wrecks and all kinds of stuff. And, we don't have salt trucks and we don't have chains on our tires and we don't have the kind of stuff that you have up north. Like when it snowed in the panhandle just recently, I was watching a storm chaser and he kept saying, "Where are all the salt trucks?" And I was like, "Dude, what are you talking about? We don't have salt trucks in Florida. Why? Use some logic. Why are you even talking about salt trucks?" Yeah, I wouldn't either. I have no idea how to drive in snow. Absolutely no idea. I wouldn't even try it. Now my mom is from, well, of course you do, Nancy. You're in Massachusetts. My mom learned to drive. She's from Virginia. So she learned to drive in the mountains of Virginia. But I remember as a teenager when we would go back to visit, she would be like white knuckling the armrest in the car because she would be so afraid in the snow. And my dad, born and raised in Florida, well, he was a highway patrolman too, so he knew like all kinds of stuff about driving that we didn't know. Um, but he was a good driver, so there was no reason for her to be afraid, but she was scared to death of the snow. And I'm like, Mom, didn't you learn to drive up here? Like you lived here, you drove, you had kids up here and drove in the snow. Why are you so scared? Like I didn't understand it. Sorry about that. I was just, um, I'm gonna miss Judy. I want to cry. I want to cry. Judy will be gone for a week. Dang, I can't believe I'm getting teary eyed. Oh man. She's gonna watch this on her laptop tonight. Oh man. Judy is on the road right now. She is going on a cruise, and they left this morning to drive to Orlando. They're leaving from Cape Canaveral on Saturday morning to go on a cruise. Um, so she will not have Wi Fi on the cruise because she said, oh, no, no, it's not bad. It's not bad. Hey, Robbie, it's not bad. It's just that, like, she's my right hand woman, and, like, she's always here and she's always encouraging me, and, like, she'll text me and remind me, like, to put up a content warning or whatever, or she sends me documents, and, like, she'll text me and say, I just sent you this, and I'm just gonna miss her. Um, she said that Wi-Fi on the ship, for a week of Wi-Fi on the ship, it cost as much as 3 months of Wi-Fi at home. So she didn't get it. I don't blame her. That's a lot. However, I'm kind of addicted to the internet, so I don't know if I could go a week without it. I really don't. There would have to be a lot of activities on a cruise ship for me to be able to go without internet. I'm just saying, I don't know if I could do it. When I was in high school, our senior trip was a cruise, and oh, they're in the courtroom. And there really was not much to do on the cruise for teenagers back then. Oh, there's no on a cruise, but we were chaperoned. That's weird. Why did my mic get quiet? Oh yeah, she's fine. Why are what? I don't understand what's happening in court. Well, I just don't understand what my computer's doing right now. It's being weird, and that is nothing new. Why are so many windows open? For the longest time, For the longest time, he was just standing there saying nothing. Come on, StreamYard.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what
All right.
our concerns are in my.
Dang it.
oral statement.
All right. I'll hear
The
you.
court- May I?
Yes.
The court started by asking, what is it that the defense is asking for?
You guys, hang on a minute. I don't know what I did. Somehow, all of my tabs got turned into different windows. It did this yesterday. I don't know how I keep doing it. It's driving me crazy.
Of automation.
But
See, for the longest time, he's just standing at the podium.
to save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
Of automation.
But do I bother reading your expert's affidavit again so it's not in there?
Okay.
And I'll
hear
the
you.
court- May I?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amber scandal. Had a bunch of cases going back from 2010.
Wait just a minute.
And he cites Commonwealth v. Firth. indicating that sanctions may be imposed under Rule 14, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violation? Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time, and that time is January 29th, 2022.
Okay, for anybody that is not I am so sorry, y'all. This should end after today. When I get my new internet this afternoon, this should be over. All this crashing should stop. Um, I was going to explain for anyone who does not know why this is what this hearing is. This part of the hearing. I don't know if they're going to do other motions. This motion is because Karen Reed paid for an expert to come out and view the Sallyport video, the original Sallyport video. It was shown at the first trial. It was shown in revert, like a flipped image of it, so that the tail light that was broken, it was not said during the testimony. We were made to think we were looking at the tail light that was broken when we were actually looking at the other tail light. So that, and also the people in the video, they would just appear out of nowhere. So the video was edited, and the explanation for the editing was that it was a motion activated camera. Well, that's not how motion activated cameras work. When it detects motion, you will see a person walking up to a camera. They don't just suddenly appear, because the minute motion activates it, it starts recording. So they flew someone out to analyze the original unedited, untouched video, and there was no unedited, untouched video. It had been overwritten. So she paid whatever, flight, hotel, whatever, plus his fee on top of that, and there was no video for him to watch. So they not only want that money back, but they're wanting sanctions against against the Commonwealth for all of this. They're saying it's a Brady violation, and a Brady violation is when the prosecutor has evidence that could exonerate the defendant and they don't give it up, which if you watch the Alec Baldwin trial in the Rust case, yeah, this one is a fascinating one. Yeah. So if you remember the Alec Baldwin in the Rust movie trial, the reason why they did not he got cleared of that shooting was because of a Brady violation. Okay, let me see if we can get let me turn off my camera right now, because that's what keeps crashing it. My camera being on and video at the same time, it does not, my internet can't handle that right now. But it will after this afternoon. Hopefully. It better.
Are these Sallyport videos? It should be pretty straightforward, really. I mean, it's just these videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's 24-hour period, 23 hours and 59 minutes. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request.
I just told you the first date.
Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. And I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to that material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts professional.
You guys, I am so sorry. Yeah, you're right. That would also prove that they're lying. Because that's not how a motion activated camera works. I know. The thing that I keep saying is that I and remember, I'm a nurse. I've seen multiple people with car accident injuries. I've never seen someone driving or being struck with no injuries on their lower extremities. Never, ever in 17 years of being a nurse. Never. In or out of the car. Karen's car bit John. Yeah, and I don't understand how the jury listened to the guys from ARCA and ended up with a hung jury. Like I truly don't understand that. Truly, because they were very, very clear. Very clear.
Time frame that the SUV was being pulled into the Sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sallyport, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sallyport video just a few days ago, this one showing the Lexus backing into the Sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled
am so sorry, guys. Yeah, Ardo, you are absolutely 100% correct. And I mean, he is in a way. Like, he's going to lose his job. But yeah, he should be. And with all the Sandra Birchmore stuff and what's the other guy's name? I did a video on one of his hearings, one of his discovery motion hearings. I forgot his name. Dang it. Oh, I could try that. It was it was doing well yesterday morning. I didn't have it was later in the day I started to have problems yesterday. I don't ever know. This just started happening like a month ago. Because I did Ashley Benefield's trial, and I want to say I did Sarah Boone's trial, and I didn't have a lot of problems. And then all of a sudden, it just didn't want to work right anymore. It's already on 720. If I go down to 480, I wonder if it'll be blurry. No, it doesn't look like it'll be blurry. Maybe it'll be okay.
Showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and
Hey, Melissa.
experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Miss Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh, yes, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage. You get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them.
No, you're not confused. What happened at the first trial was great. I just lost another window. What is my computer doing today? Oh my word. I don't know what's going on. What they did was they downloaded it, they flipped it so that the broken taillight was hidden, and it led us to believe we were looking at the broken taillight. But actually, it was hid right, it was inverted so that someone could have actually been at the other taillight doing something to it. And we couldn't see that. And then there were people just popping up out of nowhere. And that excuse was it's a motion activated camera. But that's not how motion activated cameras work, because they start recording when they sense the motion. They don't just pop out of nowhere. Well, they wanted the original footage before it had ever been tampered with. And that had been overwritten on the DVR. Yeah. So it had been overwritten on the original DVR. So they flew this expert out to get it off of the DVR, and it had been overwritten. So I guess the Commonwealth got rid of the original video after they tampered with it, I guess. So and they didn't say anything. So that expert flew all the way out for nothing.
By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason, zero. The 30-day override protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much. Mr. Brennan?
Well, he did say it was a Brady violation.
It's notable that the defense
Oh, he's
purposely
hot.
conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive what they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted.
They didn't create
It is
it.
disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom.
You're
who work
embarrassing.
out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that NVR. And respecting his position, providing a professional courtesy, I agreed. I didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. By the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could. Maybe since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras. I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information supposedly on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy in an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Any quick response, Mr.
Very,
Jackson?
very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also great, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all.
Don't he was hot.
It's in the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought on this case not to represent Mr. Brennan, but to represent the Commonwealth, and ultimately are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right? So my request to come out and have an expert come out and see it. That's not just, you want to keep your hands clean. Let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure. I didn't even interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one that downloaded it. You can't, I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the right protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but
Don't be
demand
sorry.
to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd, I don't know what the docket number is. It was filed on February 2nd after arraignment,
Here?
wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed? And Mr. Brennan
No,
actually.
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
so-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as
as an
exhibit.
attachment, but it was
but
never
not-
any,
Right. There was, I don't mean to cut off the
no,
court,
no.
Judge.
It was never brought before me or a judge who had this before me.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act, I need to see.
By the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamp. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Graziano was talking about when he talks about in the committee case, the self-executing duty that a prosecutor has to. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually pursue. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that information existed, the DVR existed. Sorry, the video footage on the DVR existed, and we were going out there to. Now, we shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not. I think we can all in this courtroom agree. None of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR NVR. That's the actual system that keeps all the footage that's recorded.
That
That has been served.
commonly is overridden every
Yes.
30 days, like
Has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy, and it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was
Well, that's stupid. If you know that there's going to be a trial, you should make a copy and put it in a separate file and leave it there for preservation for people to get copies for the trial. It's common sense. If it's some little piddly thing that is not going to amount to anything, then yeah, let it overwrite it to save space. But make a backup of the important stuff so that anytime anyone needs to come in and get a copy, It's there. It's so frustrating. It's such a simple solution. If they would just use their brains. I think the cold. It's the cold. Is it the cold? I don't.
Was a request for the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I of what he would provide to the court and the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Bennett about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first.
Yeah. So let's try and work it out before you leave here today, okay?
I'm happy to defer at the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive, but we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss, whatever the remedy is, because they think they've been aggrieved, that would be a different motion. This motion is they're trying to get the court, or asking the court, to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right. All right, so let's move on to the Commonwealth's motion for clarification regarding the search warrant, or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Ms. Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum, or attaches addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect for the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. They have a remedy. It's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay, is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, it was a communication we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the ground.
It sounds squarely within the search warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. On January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, we can get the. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with.
Why sidebar?
I
Sidebar.
prefer to find out
Sorry,
what's going
sidebar.
on over in federal court at sidebar first.
Yes, Your Honor.
Oh, because it's in federal, something in federal court? Jeez. Did you type that, Melissa, or did your voice to text get that right? Oh, forgot about Snidebaz. At least it's not her hands. There's one law and crime cameraman that likes to get everybody's hands for some reason. Yeah, when we watched this on Legal Bites channel, we watched the first trial. Snidebaz. and everybody had cross-examnesia, because as soon as everybody got cross-examined, it was, I don't recall, I don't recall, I don't remember, I don't recall. So they all had cross-examnesia. You guys go check out As the Gavel Drops. That is a wonderful Discord server that gives me a shout out every time I go live or put out a video. What shirt with the solo cups? I haven't seen this shirt with the solo cups. I haven't seen that shirt. I want to see that shirt now. I'm going to have to make him show me that shirt. Yeah, the reason I knew of RA, I knew of Scott, but I hadn't watched him. I mean, I had watched him like here and there. Oh, okay. Send me a picture. I had watched him a little bit here and there, but I was a mod on Linklebite's channel, and then she had a baby, so she quit streaming trials. So I started streaming trials. Yep, he is how I met you. So I started streaming trials kind of to help her out so we could all stay together until she came back. And then we didn't stay together. And I just had so much fun that I kept doing it. And at the same time, I miss now being over on Scott's channel, but I still get over there when I can. Like yesterday, I popped in after Colin Griffiths' verdict. Thank God we don't get so much lollygagging. God. Oh yeah, like there's a trial now going on right now. Something about a baby thrown in a dumpster or something, or a garbage can. I'm not doing that. There's no way. Well, I went into I don't know, you might disagree with me, Melissa, but I went into the Colin Griffith trial thinking, oh man, this kid. I was like, she got what she deserved. I'm sorry, but I was abused in similar ways as he was, but not as bad. So I was happy. I mean, I get what you're saying. You deleted it, but I can still see it on StreamYard. But I get what you're saying. This is true. You're not wrong. Oh my gosh, I have never even heard of that show. Oh, okay. I didn't see the typo. It's just I know I'm looking at it through the lens of an abused child. I was not abused as badly as he was. But I know what it's like to live under the umbrella of a controlling mother. Yeah, my mom. Here, I'm talking about my abusive mother, and then I go to talk about my mom being a mom at 16. My mom wasn't physically abusive. She was, I don't know if it's mental or emotional or psychological. I don't know what label of abuse that is. She was controlling, like overly controlling. And the one thing that keeps coming back in my head, like it was, I mean, we were fine when I was little. But as a teenager, when you ask your friends, why don't you ask me to go do things with you guys anymore? And they say to you, because your mother never lets you go anywhere. That's traumatizing. When even your friends know that your mom is, because then you just feel like a freak. And it affected my self-esteem and the way I had interpersonal relationships for years and years and years. I'm only now, and I'm 56. I'm only now starting to have any type of self-confidence in myself. Yeah, and when it's a parent, you don't know that you're being manipulated and controlled because you think they're my parent. I have to do what they say. This is what parents do. Yeah. Yep. Are we behind it all that we can fast forward through some of this stuff? Oh, we are behind more than I thought we were.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses to trial.
And you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson?
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting. within that, some individuals we've never seen anything from. There, upon review and analysis, those some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. A reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think it's going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it the last trial, the same thing, forecast, and then it's coming, it's coming. I need motion in order to get it heard before then. Let me hear what the court has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I-
You guys, this may not be proper, but I don't care. You're my friends and I'm sharing this with you. I kept seeing all the things about the Roundup lymphoma settlement thing. And I thought, you know what the heck? I'm going to try it. So I sent my information in and I got a response. And it says, "Hello, Deborah. I have reviewed your Roundup claim request and it appears you may have a great claim. To move forward, I need to discuss a few details with you. Please call me at your earliest convenience so we can proceed with the next steps. We look forward to assisting you." So you guys pray, because my neighbor and my husband was spraying Roundup in our yard. Like, I don't know how often, but like they started doing it around 2010, and I came down with B-cell lymphoma in 2014. And my husband's like, "But how come we didn't get it?" And I'm like, "I don't know, but I got it. And I was around the Roundup just like you guys were. So I wasn't out there spraying it, but so."
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. We'll hear it. If there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. Talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So I'm giving you
She's
from
not going to
February
grant it.
11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
She's not going to grant it.
Commonwealth, I'll give you to the 28th. Okay.
Thank you.
All right.
So when are you having the hearing now?
We're going to take let's keep it on now. If you work out they're talking to do a voir dire of those witnesses, we've got the 18th free.
So what?
February, you were supposed to be here anyway on your motion to dismiss.
So what day are we doing the motion to dismiss
Okay,
now?
I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I? show
Okay.
The defense.
Sure.
Oh, it's an extra copy? Okay. This one, if you want it. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
Oh, gosh. Why? I don't understand why they have to go sidebar. I don't know. Well, I can't get your comment up. There it is. I don't know, and I don't know how to find out. See, the two trials that I started with were Florida trials. That's super, super easy to find Florida trial documents. So I thought it would be easy to find any trial documents. I was incorrect. Florida just likes to be transparent. Other states, not so much. And I don't have any money. So I have no idea, but I'm assuming they ruled they're acting like they're still going forward with everything. I've not heard anything about any counts being dropped. Yeah, we do. We show our. I keep trying to tell people that we're not all crazy. We are just transparent, and people still don't believe me. I'm afraid of Florida. I don't want to come to Florida. I wouldn't want to live in Florida. Just like Florida's amazing. Come to Florida. It is amazing. No, don't come to Florida. We don't need any more people in Florida. Yeah, but you've had a good reason for missing stuff. Yeah. Some of us are very normal. Well, but I'm good with that. That's why I stay home, though. I don't go many places. Yeah, I like where you are. Because you're close to the theme parks, though. I am close enough that I'm comfortable. I can drive there in a day and get back. Travis, he lived in Mulberry, which is just south of Lakeland. What? You have got to be kidding me. Oh my God. Okay, that has got to be illegal. I think I'm speechless.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
It's a controlled substance, for one, and alligators are still protected, right? Aren't they? Aren't they? I don't know, because they get protected and then they're unprotected because there's so many of them, and then people kill too many of them and then they get protected again. And so I never know when they're endangered and when they're not, because I'm sure they looked happy. Oh my God. Oh man. Oh my God. That is bizarre. Because people that aren't from Florida, they always I better not catch you doing that. I better not catch you doing that. Oh my gosh. You hear people from out of state being afraid of alligators, and I'm always like, they're not going to bother you. They don't come around where people are. They don't. If you go out in a boat, if the boat even goes close to where a gator is, like on a log or on the bank, they will dive under the water to get away from you. Even a boat that goes close to them, they don't want to be around people. I swim in the springs all the time. The springs that feeds the river where all the alligators are. I've never seen an alligator up in the spring because it's always full of people. Never. There was one time they closed the spring. Yeah. And they don't allow it at Manatee Springs State Park and what's the other one we go to? Fanning Springs State Park. They don't let you bring dogs down to the springs. I think you can have them at your campsite. Like if you're camping there, you can take them, you can have them at your campsite, but you can't have them down by the water, which makes sense if you think about it. That's why, because of wildlife, alligators and such. But there was one time that they close. Yeah, you do. We live in Gilchrist County. That's the natural spring capital of the world, I think. We pass the sign all the time. I think it's world. Is it country or world? I think it's world. But there was one time they closed the springs. They closed Manatee Springs one time because a gator was nesting in the spring. And when they nest, they're territorial. And that gator was not leaving. So, they had to close it. They had no choice. They couldn't get her to leave her eggs. And I don't blame her. If I was a mama sitting on eggs, I wouldn't leave either. Yeah. So extremely understandable. Yeah, you don't want to mess with a gator that's nesting. But other than that, well, I mean, I didn't see that one because it was closed. They closed springs. But I've never seen now manatees. Oh my God, yes. I've never seen that because I live in North Florida. Like even when I've never lived that, well, I was born in the Keys, but we moved when I was 6 months old. But people don't believe that. They think you're kidding when you tell them that. It happened at Disney? Because, well, Sarasota's south of Disney. Yeah, but for some reason, Orlando weather is like more. It gets colder in Orlando than it does like up here sometimes, it seems like. Because I have been in Orlando and I have been super, super cold. So maybe. But yeah, that's true too. It did get a lot colder. But are there iguanas in Orlando though? Because aren't they farther south? Because like I lived in Sarasota and I don't remember seeing iguanas in Sarasota. I've seen them in the Keys. I think they're about the same size. I'm not actually sure. I know that crocodiles have the pointed nose, whereas alligators are the more like square. That's the way I tell the difference. And we have what are our crocodiles called, Melissa? Are they just American crocodiles? Oh. And I don't think I've ever seen a crocodile in the wild. I've seen a lot of alligators in the wild. But we saw, I don't know if there are still iguanas down in the Keys when I'm talking like Gila monster big, like giant iguanas. My cousin and I were staying with my aunt and uncle, I was staying with my aunt and uncle, me and my parents. We went down there to visit. I was born down there, but we would go back to visit. And so me and my cousin, we were playing in the yard, and my aunt and my mom had gone shopping or something, and we were there with my uncle, my dad. And we were playing in the yard, and we see this giant lizard. And my dad and my uncle saw it too, and they came back from shopping, and we told them, and they didn't believe us. They thought we were making it up. No, I swear. This thing was like the size of a dog, size of a small dog, and they did not believe us. Where are caimans from? I know what you're talking about. I've seen pictures of them, but where do they live? Yeah, when you tell people to watch for falling iguanas, they don't believe you. No, it's a real thing. And if you Google, it's so sad. Look at these pictures. It is so sad. They look dead. But they say not to touch them, just to leave them. Because I think there's something on their skin that can give you an infection, like if you have an open wound or something. But like if they're in danger, like if they're, well, I guess they're not going to fall out of a tree onto a street or anything, but they could fall. Oh, good Lord, somebody put a sweater on that one. Are you kidding me? Oh my God. I am surprised. Who puts a sweater on a wild iguana? That has to be somebody's pet. No one's gonna get a wild iguana. It's got to be a pet. There's a dog on a bed in the background. That looks like somebody's couch. That's a pet. That's a pet iguana. Has to be. It's so sad though. But yeah, can you imagine though getting smacked in the head by an iguana? You're just walking under a tree and falling iguanas this morning. Iguanas are cold-blooded. They slow down or become immobile when temps drop into the 40s. They may fall from trees, but they are not dead. When do Florida iguanas fall from trees? Below 50 degrees, iguanas slow down. 40 degrees, iguanas become stunned and cold for up to 8 hours. Below 40 degrees, iguanas become incapacitated. Oh, look at that one. Falling iguana season. we have summer and falling iguana season in Florida. Yeah, some of these yeah, they're not venomous, but the bacteria. And I think with iguanas they have like bacteria on their skin. I mean, I'm sure their bite's pretty nasty too, but yeah. Yeah, pretty much. Yep. Those are our seasons. There you go. That's what we need. More Florida crazy. Oh, yeah, that's always possible too. Okay. Okay, I am gonna I'm gonna go and make the thumbnail for the dog park murder trial and try to find the one that we're starting today. And then we're gonna hop over there. So I will be right back. So please join me in the new feed. I love you guys. Thanks for coming out. And join me over there in a few minutes. Okay? Bye. Love you guys.